Hi, everyone. Thank you for joining us and welcome to day one of Bread and Net 2021. My name is Afef Abrougui. I am a research lead at SMEX and a consultant and researcher working at the intersection of technology and human rights. I'm going to be the moderator for the session on the opportunities and human rights implications of digital ID. The session is part of a research report we're currently working on at SMEX on digital ID in the Gulf region. This research and this report, which will be published next month, would not have been possible without the support of Privacy International. And the report is also part of a broader research that SMEX will be conducting in the future to map the different digital ID programs and initiatives in the Arab region and their human rights implications and impacts, particularly on the right to privacy and on marginalized communities. Before we start the panel, I'd like to first introduce the speakers. First, we have Omar Daouk he's a Lebanese legal researcher at SMEX and the project coordinator for Mohal, which is SMEX's online freedom of expression case database. Omar is based in Paris, where he is pursuing a master's degree in digital rights at Panthéon-Sorbonne. And his research area or his research interest is the intersection between law and technology. During the session, Omar will be presenting preliminary findings from SMEX's new research on digital ID in the Gulf. Next, we have Constantine. Nai is a legal consultant specializing in intellectual property and information technology law, and she's currently working in international development on digital economy and digital identification projects. Nai will be speaking about opportunities, challenges, and international best practices for digital ID. And finally, we have Subhashish Panigarhi, who's joining us from India. Subhashish is a documentary filmmaker and researcher who has extensively written about the rollout of Aadar in India. He is the director of O Foundation, which is a nonprofit that uses digital technology to make social innovations. His areas of interest are digital inclusiveness, language, digital activism, and openness. Subhashish has been responsible for building communities and programs at Wikimedia Foundation, the Center for Internet and Society, Mozilla Internet Society, and Ashoka. As a IoT Digital Identity Fellow, he created a documentary titled Marginalized Aadar on India's biometric ID and its impact on many marginalized communities. Today, he will be speaking in the session about the rollout of Aadar in India and its impacts on marginalized communities. Thank you very much for joining us. And first, we will start with Omar to present about preliminary findings or some findings from SMEX's new research.
Hi, everyone. It's great to be here. So yeah, as Afef already mentioned, thank you for the introduction, Afef. As she already mentioned, I will be talking about what we found during our research for digital ID. I'm going to start off by just giving a small definition or just defining what digital ID is so that everyone is familiar with the topic that we're going to be talking about. And it could have different meanings in general. Digital ID could have different meanings in general, but it's usually just a set of attributes. It could be biometrics, a name or an identity number, and some credentials that are electronically captured and then stored. And these credentials are used to define to uniquely define a person. These digital identities have been used to identify and prove someone's identity, whether it's online or offline, and that would depend on the uses or the context in which it's being used. We can use digital identity sometimes, for example, to access government services, to apply for welfare aid. In some instances, we found that digital ID was used for voting in elections, for example. We focused during our research mainly on GCC countries, which are countries from the Gulf Council cooperation. All of these countries seem to have adopted and implemented a digital ID system that allowed their citizens and the governments to have and to provide access for services and to perform transactions online. What we also found is that these GCC governments have put in place these ID systems that generally rely on modern technology, which are often biometrics or smart chips. And these ID systems allow people to identify themselves, authenticate their identity online, or even become eligible for a certain number of online services, among which are administrative services. So ID systems have really evolved in these countries to have a big role between the relationship between citizens and their governments to even facilitate that role. I'm also going to be talking about some of the authorities that were responsible for and the service providers that were responsible for implementing these digital ID services. What we found is during our research is that all of the GCC countries have managed to hire Thales, which is a French multinational company that is responsible for designing and building electrical systems, and even provide services for aerospace, defense, transportation. We found that Thales has had a key role in implementing digital ID programs. Now, the extent for Thales's involvement or for Thales's role differed between these countries, between the GCC countries. However, it is certain that Thales has had a role in the rollout of the electronic identification systems. For example, I'm going to take example Gemalto, which has been acquired, which is a system that has been acquired by Thales in 2019. It was contracted by several countries, such as the Bahraini government, to not only provide smart ID cards, but also to provide consultancy on smart card related solutions, such as public key infrastructure and smart card applications and training. So we noticed that Thales has had a big role in and a big involvement in the rollout of all of the digital ID systems, and even sometimes it even had bigger roles depending on the country, of course. Now, each country didn't just rely on Thales; it also relied on several other entities of its own, where it had to either create entities specifically for these purposes, or it had pre-existent entities that managed to take on that role. I can take, for example, some ministries. Some countries chose to use or to rely on their ministries of interior, maybe some ID authorities that they had previously, such as PAKI, which is the Public Authority for Civil Information in Kuwait. All of these institutions and entities have had a role in implementing these ID programs. Now, these ID programs are do have some human rights implications, because some of them are not mandatory, but a lot of them are. These ID systems, we found that they have increased the government's power to restrain freedoms, to restrain civil liberties, for those who refused or couldn't. Sometimes they couldn't enroll in such systems. Some people are ineligible to enroll in such systems. So in some instances, we found that some ID systems are mandatory while others remain voluntary. But overall, any ID system where it's directly linked to an administrative form has been proved to be detrimental for the residents there, which also, as I said, poses a risk for the human rights of some of the people there. Now, speaking of human rights, we have to talk about the existing regulatory frameworks that we found there, because ID legislation is very important in these countries, so that we can have a legal framework that regulates the implementation and the breach of the privacy of some people, for example, or the regulation of the ID systems. So we found that a number of countries do have legislation specifically establishing digital ID. In Oman, for instance, the government launched the electronic certification service that was provided by the National Digital Certification Center to provide electronic access to government services and transactions using digital authentication. What's more important as well is that it's important to note that the digital ID systems do collect a lot of the personal information from their users or from the people who are enrolling in these systems. So it does a lot of heavy processing from the personal data, and this creates a real risk on users' privacy. So having safeguards for data privacy, security, and user rights is very essential to build the trust in the ID system. While most countries who have adopted data protection laws have resorted to standalone legislation, we found that in the GCC, only Bahrain, Qatar, and Saudi Arabia have passed general laws on personal data protection. And this is something that is very important to note, because the three other countries did not pass general laws on this topic alone. Digital ID and cybercrime legislation, it would help protection against some crimes, such as the unauthorized access to some ID systems, or other databases holding personal data of ID holders. It can also protect towards surveillance of ID systems. So these legislations are very important in order to stop these unauthorized accesses or monitoring. Now, we did notice that when these laws do exist, such as in Bahrain, the countries that I mentioned before, Bahrain, Qatar, and Saudi Arabia, The language remains very vague, with broad assumptions for public authorities, and this leaves a lot of room for human rights infringements or for human rights implications. Vague language is not very specific, and it leaves a lot of room for questioning whether or not these legislations do protect users' privacy and their rights, or if they don't. We also found that there was a lack of strong independent oversight, where overseeing these ID systems would be an important step towards protecting users' rights. But the countries we've been studying all lack this strong and independent oversight over data collection and protection of privacy. We were able to identify two main issues, which are the lack of independent oversight over the data, and the lack of independent oversight over the ID systems to ensure fairness and to prevent exclusion. And this brings me to the last point I was going to talk about, which is exclusion, because we found that marginalized groups have been subject to some discrimination with these ID systems. We noticed that there has been generally two types of discriminations, which are gender-based and then on people with disabilities, because we found that there was in some countries we have gender discrimination because when it comes to women's right to register their children, we found that in some cases women were not allowed to register their children, which causes a problem when they want to register to digital ID systems, because they couldn't have digital ID systems because in some cases they needed to have just regular IDs, which they couldn't obtain. Also, in addition, we found that people with disabilities could not use or access digital ID systems because in most cases the countries used biometrics or iris scans to be able to use digital ID systems. So a lot of people with disabilities are not able to do this. We found that some countries were able to exclude these people from having to use these systems, and we found that there were systems put in place specifically for these people. But there remains a big question on whether or not marginalized groups are actually protected in these and have the rights in these digital systems or not. And yeah, that's it. Thank you.
Thank you very much, Omar. A couple of questions, but before I ask them, I would like to give Nai and Subhashish the opportunity in case you have any comments, any initial thoughts to these preliminary findings.
Thanks, Afef. Thank you so much, Omar, for this introduction on ID systems and presenting the GCC landscape. I think that the Gulf landscape is just an example of what is also happening in many other countries, in the sense that implementing and designing ID systems, especially when they're digital, can pose challenges on a certain number of aspects that Omar was mentioning, be it non-discrimination and exclusion of vulnerable and marginalized groups, or protecting the system's security itself and protecting users' privacy. And I think it's important that we're highlighting this in today's panel, because it's often something that governments will have to look at and bridges and gaps that they will need to bridge.
Thank you very much, Nai. I do have a couple of questions. So the first question is, you mentioned that in some cases you encountered vague language in some of the legislation you were documenting or you were working on. And specifically, I think data protection laws. And my question to you, could you give maybe an example of how did that vague language look like, or what did it deal with exactly, if there was anything in data protection laws in particular that need to be noted?
Yes, sure. So, I mean, for vague language, usually they can use, I mean, in some governments, I don't remember which ones specifically, but I found that in some articles of the law, we don't really have specifications regarding what type of information is being collected. So in some instances, we can find that, or maybe we can find that they don't really specify how long data should be stored for. So we find data should be stored for however long needed, which doesn't really give us an answer how long this data should be collected for, or how long this data will be collected. In some cases, we also found that some of the language was vague in regards to the type of data that will be collected, because sometimes I managed to find some articles in which I only found personal information is going to be collected, but I couldn't find what type of personal information is collected. So what is it specifically? What type? They could give us examples. Sometimes they give examples, but it's not very precise, which causes a problem, because we don't really know what information or how heavy the collection of personal information is. So we kind of don't have the full picture or the full image in order to better implement security measures and protect this information, this data that is being stored.
Thank you very much, Omar. I'm not sure if anyone from the panel have any comments regarding this. All right, I'll move on to the second question I have for you, Omar. So across the broader Arab region, there are a number of initiatives in progress to introduce digital ID systems and programs. So we do know, for example, that there are at least some attempts to do this in Morocco and Tunisia. And what I wanted to ask you, in your opinion, and giving the context in the region, what type of regulatory reforms should governments enact to better protect human rights and privacy before they start implementing digital ID programs, and why?
I mean, for regulatory reforms, I think having specific articles, even codes related to these digital ID systems is very essential. The fact that we only have 3 of the 6 of the GCC countries that have specific articles and codes shows how much these ID systems are not regulated for the time being. And I think having these articles is very important for that. It's very important to even have them, because with using them, we can include all the rights that are given to users generally with newer and international legislations. We find that there are a lot of rights that are being given to users, especially on the online space, in the online civic space. We find that there's a lot of such as the right to withdraw, the right to give consent, whether or not they want their third parties to access their information or not. We need to find these. Governments need to implement these articles in order to best protect their users, their residents, even. And we need these articles. We also need articles to have sanctions on whether people do access, on whether someone does have access on personal information, or as I said earlier, surveillance or monitoring. These countries definitely should have articles and legislations put in place so that they can properly sanction these violations.
Thank you. Before we move to the next speaker, we have a question from the audience, which I think we should take right now before we move on. There is a comment and a question from Osama. He said, it's not clear from Mr. Omar's presentation how the implementation of digital ID in GCC is breaching the human rights of citizens, and whether monitoring is done regardless of the use of the digital ID. So maybe Omar, if you can maybe clarify a little bit what kind of violations have you noticed, or if the violations were actually happening at the level of the national identification systems, or have there been any documented cases of violations that took place because of ID? If you could maybe clarify this a little bit.
From what I understood from the question, I think what the person is saying, so I'm not saying that there are breaches of human rights of citizens when I'm not saying that there are in each case or in every country that we found breaches of human rights of citizens. What I'm saying is that there is a possibility, which is a risk, which poses a risk in itself for human rights. Now, that being said, what I said earlier, marginalized groups not having or not always having their rights, or not even always being taken into consideration, that kind of constitutes as a breach for human rights. So that's what I meant. I think that's what the person is saying in the question, right?
Yeah, my understanding that's what it was. Yeah. So I mean, we can just move on to the next speaker. So Nai will now be speaking about international best practices and opportunities of digital ID. I need to share my screen. Could you all see my screen or not?
Thanks so much, Afef. I don't know if you're still here or you just muted yourself. Would you mind please going to slide number 3 for me? Thank you so much. So thanks a lot for the introduction, first of all. My presentation will be mainly focused on the opportunities, challenges, and best practices when it comes to digital ID. I'll cover a few questions and issues. I'll discuss why we're talking about ID so much lately. I'll also try to cover why should it matter for governments and why should they care. I'll then move on to the challenges that implementing ID systems may raise. And I'll wrap up this presentation by giving examples of legal and policy best practices from regional and international contexts. So why ID? Why are we discussing ID today? As of 2018, 1 billion people around the globe face challenges identifying themselves. Statistics show that these people are often present in low-income countries, and mostly concerned by the lack of ID documentation are vulnerable groups, and these include women and girls. More than 1 over 2 women in low-income countries do not have ID documents. But it's also about migrants, refugees, stateless, those living in rural and remote areas that are far away from registration offices, and people living with disabilities. It's therefore important to acknowledge that there is an identification gap, and not only there is an identification gap, but also it is a global one, and governments may want to bridge that gap. So why should it matter to governments? Why should they care about enhancing their digital ID systems or ID systems at all? The global identification gap is critical because having an ID can either limit or enable people's access to vital services, as Omar mentioned earlier. Having an ID means being able to access financial services, satisfying KYC requirements, opening a bank account. It also means accessing basic education and accessing basic health services, from getting a private insurance, enrolling in public medical care systems, but also, as we've seen lately in the COVID-19 context, countries that have had that had high coverage of ID systems were able to leverage them and use them to scale up their assistance to their population and roll out vaccination campaigns more efficiently. So by working on their ID agenda and ensuring that people can access these basic and vital services, countries would be paving the way for their own sustainable development. And this is the reason why the explicit objective of the UN Sustainable Development Goal 16.9 is to provide legal identity for all, and including birth registration for all by 2030. Designing an inclusive and a trusted ID system can help achieve that goal, but countries will naturally need to mitigate some risks, and there's a broad range of challenges, as Omar highlighted earlier also. Several factors can preclude an ID system from being designed in a trusted and inclusive way. These factors include political challenges, legal ones, and also some technical ones. I will be focusing mainly on the legal challenges given my legal background. But just to give you an example of a technical hurdle that can occur when implementing ID systems, often when countries, for instance, depend on a specific vendor for ID systems, for providing ID cards, this can create dependency on this vendor, can create risks of locking in data. Vendors may, for instance, refuse to transfer knowledge or capacity to governments. And overcoming this might be really challenging if you don't have in place very strong procurement practices. So for the sake of this presentation, I'll be focusing on 2 main challenges. The first one is privacy and security. ID systems, as mentioned earlier, are associated with an important processing of personal data that can also often be sensitive. And with the emergence of new technologies and the digitization of ID systems, these risks have only increased. So the risk of turning the processing of personal data into privacy violations and cyber threats are real. And another important challenge that I would like to discuss today is exclusion, that has also been mentioned earlier. implementing ID systems and digital ones can reinforce existing discriminations and further exclude already marginalized groups. Some examples of barriers to inclusion can be, for instance, internet penetration. This is definitely not the case in the GCC countries, where internet penetration is considerably high and among the highest in the MENA region. To give you a couple of figures, in 2018, the UAE's internet penetration rate was almost 91%. In Saudi, it was 73%. And in contrast, in Egypt, for instance, it was as low as 43%. But low internet penetration can be a challenge. And this can also particularly affect people who do not have a strong digital literacy or technology literacy. Other challenges that may be the case for the GCC countries when it comes to exclusion and discrimination is procedures and requirements to obtain or enroll in ID systems that can be in and of themselves or indirectly exclusionary. So requiring nationality or requiring birth certificates prior to obtaining a national ID card and residency requirements can be challenging and can deter people from registering and obtaining IDs. In the case of GCC countries, I think that the most frequent requirement for obtaining IDs is usually residency, and this can prove to be discriminatory in the sense where residency requirements are also often contingent upon obtaining an employer's sponsorship or enrolling in an education system. So a certain segment of the population who was not able to obtain employer sponsorship nor enroll in the education system risks to be marginalized. So exclusion, privacy, and security challenges can be definitely, they exist, but they can also be overcome by adopting some key best practices that will ensure that ID systems, and specifically digital ones, are designed in a trusted and an inclusive way. So there are a couple of technical and design-related best practices that can be suggested. I'm not a technical expert, but I can acknowledge a few of them, but I'll focus on the critical aspect of the legal enabling environment for digital identity. To have a trusted ID system and a digital one, countries need to enhance and strengthen their legal, regulatory, and operational frameworks. For this, they'll need to focus on safeguarding data privacy and security on the one hand. And on the other hand, they will also need to make sure that the legal provisions and procedures and requirements for obtaining ID and enrolling in an ID system are also non-discriminatory. When it comes to safeguarding data privacy, security, and users' rights, this can be done through having a comprehensive data protection law. Some countries may choose not to have one law, but may opt to have some sectoral laws that exist in various areas in different disciplines of the law. But having one comprehensive data protection law that provides for essential principles that are often enshrined in texts such as the European Union's GDPR and Convention 108 Plus, could mean lawful basis, having a lawful basis for processing data and specifically for processing the information of ID systems. Purpose limitation, limiting the purpose for which that data of citizens and ID holders is being processed. Data minimization, making sure that not 10 fingerprints are being collected, but only the number of fingerprints that are essential to ensure the authentication or the duplication. Accountability, making sure that the ID system, for instance, or within the authority and the entity that is managing the ID system, there is a DPO and that processing of data is being reported in a very clear way. an independent oversight, creating a data protection authority to which complaints can be made, and finally allowing for redressal mechanisms. So allowing data subjects, in the case of ID, this would be ID holders, to enforce their individual rights. This means enforce their right to be forgotten by the ID system and request erasure of their data, the right to correct incorrect information about them, and the right as simply the right to access personal information about them. Now, however, I'd like to, so it's true that having a comprehensive law on data protection is essential. But one thing that I'd like to highlight here, and this is in light of a recent decision in Kenya, is that in the context of ID systems, and particularly the digital ID systems, even in the absence of a comprehensive data protection law, it's important for countries that wish to implement digital ID systems to conduct privacy impact assessments prior to implementing such a digital ID system. And this is also something that was highlighted in the High Court of Nairobi's case recently about the Huduma cards in Kenya, whereby the court had considered that even if the Huduma card, the ID system, the digital ID system in Kenya was implemented prior to the issuance of a data protection bill, the authorities that were implementing ID had the obligation to make sure that they conduct a privacy impact assessment. How much will this ID system impact users' privacy? And this was supported in the case court by, in the court's case, by the right to privacy that was enshrined in Kenya's constitution and not in the digital, in the data protection bill itself. Sorry. So aside from data protection and privacy, there is also a number of legislation that can enhance the security of the ID system. Having a strong cybercrime legislation that will protect against identity theft, misuse of data, unauthorized access to the system, alteration of existing data in the system, and putting in place a national cybersecurity strategy, which I think in the GCC countries, one of them has a very strong national cybersecurity strategy, and I think that's Oman. This would help making sure that incidents and breaches can be reported, and they can, and through this strategy, one can establish a computer emergency response team to investigate breaches and help set some standards for information technology security of all government systems and databases. Second best practice I'd like to focus on, as mentioned earlier, would be to ensure that legal requirements and processes for enrolling in an ID system and obtaining an ID card are non-discriminatory. This can be made through amending existing provisions to remove and reduce the indirect costs for identification. So for instance, if obtaining an ID is conditioned upon having a birth certificate, first birth certificates should be free of charge. And similarly, when obtaining identity credentials is mandatory, the initial issuance of any identity credential that is mandatory to possess or access basic rights and services should also be free. Another example of non-discriminatory procedures is to ensure that those living in remote and rural areas with low internet penetration or no access to or low digital literacy, for instance, are included. Countries may want to keep an alternative way, an alternative offline way of registering an ID systems, and not only making online an exclusive way of registering. And finally, another example would also be, just like Bahrain did, and Omar mentioned this earlier, amending legislation that relies heavily on technology such as biometrics to exempt people who are unable to use their biometrics for several reasons, people with disabilities, for instance, exempt them from that requirement. And this is what Bahrain did in 2011 when they amended their national ID law of 2006 to exempt people with disabilities from providing their biometrics. So to wrap up, naturally, these are only a few examples of best practices that can be used, and other practices can be more technology focused or technical oriented, using privacy enhancing technology, working on open standards and requiring vendor neutrality can also avoid lock-ins, bridging the digital divide by promoting the literacy and digital literacy around the IT system and how it works. And finally, working on institutional arrangements and making sure that all of the stakeholders involved in digital ID systems have clear mandates to do so. Thank you.
Thank you, Nai. Thank you very much for that presentation. And I have a couple of questions. And so I wanted to ask you. I mean, you've studied these international standards, or at least the existing ones and best practices. And my question to you is: are there areas where the existing standards and best practices for digital ID are falling short, and how can they be improved, like these standards?
Thanks, Afef. I think that the answer to your question is where international standards and best practices may fall short in the ID context specifically is that it's international practices that emerge, from certain geographic areas and certain contexts that may not be fit for different countries. So in my opinion, there is no one-size-fits-all approach when it comes to using these practices. And to give an example, it may make sense for common law influenced countries like India using Aadar, or Nigeria to advocate for creating an independent ID authority, let's say, to manage ID system. Whereas this may not be the case for civil law influenced country, and specifically Francophone Africa, for instance, or Northern Africa, where for historical reasons and institutional capacity reasons, but also political considerations, all of this has led them to keep their ID systems hosted by ministries such as Ministry of Interior, Ministry of Home Affairs, Ministry of Justice, or local governments. So one way to see this is that best practices are good. They're good to the extent where countries can pull out of them certain essential principles and concepts that may serve to protect users of ID systems, but they should not in any case be replicated as model laws. They should definitely be tailored to fit the political and economic context of every country.
That's a very important point you raised. Thank you very much for sharing that. I'm not sure if Omar or Subhashish if you have any comments on this particular point or in response to Nai's presentation.
I have a very quick question tonight. Really insightful presentation, Nai, and I think I learned a lot about the sort of best practices that are important in the context of digital ID. The question that I have is, as I don't have enough knowledge about where each country is right now in terms of their digital ID program, do you see some of the common challenges, or if there's a particular trend that you see in the countries that have implemented or in the process of implementing but have the structure in place, and if you have seen anything that is common across all these countries in the light of the best practices that you shared? Thank you.
Thanks so much. Yes, I think that common challenges are specifically gathered around data protection and privacy first and foremost. it's a bit complicated for countries, specifically those who have not yet updated their existing legal frameworks when it comes to data protection with international best practices like GDPR, to adapt quickly. And the fact that they choose to implement, for instance, digital ID prior to amending their laws and updating them, this can pose real challenges. And this is exactly the same thing for other areas like cybersecurity and cybercrime, but also on ID legislation itself, which I have not mentioned in my presentation, but Omar mentioned it earlier. So many countries find themselves with codes that date from years and years ago. And particularly, I can think of a few countries in Francophone Africa which have inherited from civil codes that, for instance, mimic or are close to the French Civil Code of 1804. And procedures and requirements are still very manual. So I think if I can sum this up, the problem is that the law is really behind when it comes to being updated to how fast the technology is growing and how fast the digital world is expanding. So updating their enabling environment and their legal enabling environment has been a common challenge that I've observed so far.
Thank you. And now, Subhashish, the floor is yours.
Thank you, Afef, and thank you all for joining and listening from someone who is not from the region. I was a YOTI fellow during 2019 and 2020, and that's when I actually studied the challenges or the impact of Aadar, India's biometric ID. So to provide a little bit of context, the act in our constitution in India that governs the use of Aadar is called Targeted Delivery of Financial and Other Subsidies, Benefits and Services Act. So that is enough to say that the constitutional statute was framed around delivery of public benefits and not necessarily to create an ID, but the need to create Aadar in the first place came from what Nai was mentioning, the SDG 16.9, that is around providing legal ID for all, and that includes the birth registration. So that's the first context-setting thing from my end. Why Aadar was brought into using it as the de facto ID that it has become right now in India. The second thing is Aadar was created, or the initial design of Aadar was created by the government that was in power around 2008 and 2009. So the current government inherited the entire project from the previous government, and even though they oppose all the other policies of the previous government, they inherited and made the entire project a reality. So the actual implementation of Aadar happened when the new government took charge in 2014. So I'm still talking about the central government, the government that is in power in the center, not necessarily in the provincial level. So each province in India has, of course, different political parties that are in power. So the questions that I personally came across when I started is, was Aadar needed in the first place? And if other forms of IDs existed, and if those IDs were digital, and what are the alternatives, or what were the alternative designs that existed before Aadar was brought into picture? And is biometric ID needed in the first place? And if the other alternatives were inclusive enough to begin with, and why they were discarded. So those were the questions that I started from. And what I found out through, while making this documentary called Marginalized Aadar over the period of a year, is the project was sort of a public-private partnership and an outcome of that. So the chief architect of Aadar himself was the founder of India's largest IT company, Infosys. And Infosys was a key stakeholder in the entire process, among others, of course. And the other actors that were responsible for building the technical framework for Aadar were involved in building similar ones, basically data collection processes for the US government and many other governments. So they were quite popular and unpopular in doing that business, basically creating systems to collect people's personal data. And at that point, or even now, India didn't have a legal framework to govern the personal data protection. So the PDP bill is yet to be implemented in its fullest extent. So there's a lot of lack of clarity there around data protection and how the data is collected, how it's processed, how it's transmitted, how it's saved, and what kind of legal framework governs that. And if there is a data breach, what are the sort of processes in place to protect that or to avoid any such future data breaches? And the data breaches did happen in the past. So there's no clarity around that. I also found out that the public-private partnership itself brought a lot of questions around conflict of interest, because the same private entities that were involved as vendors were also the private entities that were funding many civil society actors that were then advocating for Aadar. And they also helped push political agenda. So India had many forms of databases, digitized and physical ones. When Aadar was brought into use, what happened is Aadar was collecting a range of personal data of individuals. And Aadar is not a database that has collected data of only citizens, but it's residents. So there's a distinction there. And residents could include many foreigners that are living in India, but have some form of ID, some form of proof that they are living in India for certain work or whatever it is, but they also could apply for Aadar. But very interestingly, the loopholes in the entire architecture, the technical loopholes in the architecture allowed one of the Indian gods, the Hindu gods, to have an Aadar in his name. There were many fake Aadar IDs that were created, and there was no response from the government addressing the issues that were built into the system. So the areas that I personally looked at are around the exclusion that Aadar created. So that includes people that speak different languages in India. So India as a country is extremely multilingual. There are more than 700 languages that are spoken in the country. 22 of them are officially recognized. However, when it comes to technical literacy, something that Nai was mentioning about, that is completely absent in a way when it comes to educating people about the use of Aadar. So the way Aadar was projected or sold to the people is it was sold as an idea that is essential for every single thing, including accessing public benefits such as ration or subsidized food grains and other amenities, accessing other benefits that are public benefits, using Aadar as an ID for verification or authentication for several government programs, and then use of Aadar for something called KYC, Know Your Customer, in many private registrations and authentication processes. So Aadar became the de facto ID in the country for all things public and private. So from being governed by the Financial and Other Subsidies and Benefits and Services Act to becoming the de facto ID, that was quite a journey. The way it affected people, especially people that are marginalized in different fronts, was quite extreme. So there were people who are disabled in different ways. So there's physical disability, mental disability, but also disability or lack of access because of lack of education or lack of literacy, and so on. So when I looked at disability, I looked at lack of access as a whole, and I found out that somebody who is disabled physically or has some form of disability, but is literate, would probably be benefited because of Aadar, whereas someone who has some form of disability, but on the top of that they are illiterate, then the challenges are multifolded for them. So using Aadar for authentication, for instance, to access ration, food grains in a subsidized price, one has to use biometrics and or a phone number. Many people don't have phones to them, so there might be families that have only one phone for the entire family, whereas Aadhaar requires a unique phone number for each individual. So many people couldn't provide a phone number, or they provided a phone number that they had access to at particular time, but they never managed to keep that phone number over the time, and they could never manage to update that. So in many places they were denied from ration or denied from their rightful access to life in many ways because of lack of a particular mode of authentication. And many people that say have a particular kind of disability, if a person had their so people that do manual work or have some form of or old age or have some form of disability might not be able to use their fingerprints for authentication. And that is one of the key mandates to provide when it comes to Aadhaar enrollment. So fingerprints might not match at a particular time. It could be an environmental factor, it could be a physical factor, it could be old age, and so on. And because of the lack of that, many people could not authenticate and could not access food. So when COVID hit the economy, many people had to depend on the relief that the government was providing, and Aadhaar was being used to access the relief, and many people couldn't authenticate and hence couldn't receive their relief. So I spoke to someone who at that point was 65 year old, and she in an accident lost all her fingers, and she was denied ration for 11 months because she couldn't authenticate. When it came to the technical infrastructure of Aadhaar, there was a lot of open washing, meaning the government promoted Aadhaar as a project that uses a lot of open source technology, and that is not factually incorrect. They do use a lot of open source plugins and software that are integrated into the entire ecosystem. However, when it comes to openness, one thing that's very important is it has to be open to the extent that the civil society, the public, are able to audit independently, something that, again, Nai mentioned. And people are also able to see and verify the claims that the government makes. So when the government says that the data center that is protecting all the data of the Aadhaar database, there is no way the civil society could verify whether or not that claim is true, because the software that is used, or the software that are used for the whole structure that is internally used are all proprietary and are still managed by the companies that built Aadhaar. So the companies that I mentioned in the beginning, such as Infosys or Accenture and several other companies, they own the copyright of those proprietary software. So there's no way the civil society could actually verify. There's also no open consulting when it came to redressal or addressing the problems that people raised over the time, because there were many loopholes that were found over the years. So where the theoretical sort of way to say that we have everything in place and we are ensuring that people's private data is protected and so on, the civil society actually found out a lot of loopholes in on the technical front, but also in the implementation process in general. And there was no open consulting where the authorities would actually listen to the civil society and make changes to the architecture and then inform. So there is no sort of log when there is a public consultation, and who are the public actors and how they were brought into the consultation process, and which changes were made based on their inputs. So those things were completely missing and have been missing till date. The other challenge that Aadar created is creating a massive database that also was used to create a much larger database. So multiple ways of data collection were used to create sort of a centralized database. And we see programs using data that could be private data that could be publicly accessed, using people's phone numbers or their first names or last names. So there was one instance when the road transport data was used to attack on shops that were owned by Muslims during a pogrom. And that was a targeted attack that a publicly available private data enabled. Aadar created, sort of amplified these problems in a massive scale. I'll stop there and wait for the questions, and that will also help share more information. Thank you.
Thank you very much, Subhashish, for this very informative presentation. I just have one question for you, and it is if there is one or two lessons that that governments in the Arab region could learn from the implementation of Aadar and its human rights implications, and particularly those governments who are in the process of launching or starting digital ID systems and programs.
There was a little bit of lag of audio, but I think I got the question. So I think one really important thing is data minimization, something that Nai also showed in her presentation. And I personally think that collecting data that is not required, but is collected for the sake of creating a system that envisions that in the future that data would be required is a wrong starting point. There are ways to not use biometric data or use biometric IDs, use digital IDs that are not biometric in nature. So collection of biometric data creates many kinds of problems and also excludes a lot of people that might or might not be able to provide biometric data. So people with disabilities are one particular group that would never be able to provide biometric data, iris data or fingerprints and so on. And these are sort of really wrong data collection practices to begin with, and that could be avoided by other ways. Smart card is one way to ensure that there is consent built into the system, which something like Aadar doesn't have. So something that Aadar enabled is consentless data collection, but also use of that data, use of personal data without taking consent of people. Whereas somebody who has access to a physical ID, a smart card, then they are able to use that to provide consent. And that's a much more secure process, because the design that many smart cards use are quite verifiable, that have been used for years, whereas biometric data is a newly emerging field, and that's sort of untested technology that is used massively. So that's another area that could be looked at. Collection of health information and disability information, gender and sexuality information. Those are also extremely private information that are not required to be collected in the first place, and always create more challenges from data protection, but also targeted harassment or misuse of sort of public, authorities could actually misuse that data to harass people in certain places. And if the sort of governing mechanism or the way to identify those issues and addressing those issues are not built into place, then there could be sort of massive harassment of minority communities, for example, in a community or in a country or a region. And I think the second thing is the access to private data, and that access given to private companies. That is always problematic. And oftentimes governments don't have the bandwidth to create a system that works, and they don't have people that are authorized by the government or are government employees using those systems. It's often outsourced to external private companies, and it's always difficult to monitor how those companies use the private data of the citizens, and that lead to a sort of private companies being benefited from private data of citizens. The last thing I would say is the use of proprietary software. Lack of openness in the entire process. Open standard is something that Nai also mentioned. I think that is very important. Using open standards and open source in the software architecture is really, really important. Lack of that not just creates lack of accountability, but there are many other challenges that basically cripples the civil society and creates more challenges for the public. Thank you.
Thank you. I do have a few questions on advocacy strategies, but I want to, because we're running out of time, I want to see if there are any questions from the audience, and otherwise I can ask my questions later. I don't see. I need to check the comment. I don't see any questions in the comments, so I'm assuming that there are no questions so far. So I can just go ahead with the questions that I have. So we know a lot about digital ID. At least we do know. We have a lot of information. We know a lot from what happened in India about how it can impact the most marginalized communities. SMEX is releasing this new research, so we're starting to also map these initiatives in the Arab region, and we also know about some of these existing standards and practices. So the question that I have, or I would like to ask each one of you is, so how do we go from here? And what I mean here is, how can civil society organizations use some of this information and research and the stories that we know about how digital ID affect marginalized communities to better advocate for strong human rights protections in digital ID system? And my first question is to Omar. So after this research publication next month by SMEX, my question is, how can civil society groups in the region use this research, its findings and data to help advocate for stronger human rights protections in digital ID systems that are either currently being implemented in the region or might be implemented in the future?
Okay, so regarding your question, Afef, thank you for the question. First of all, regarding your question, I think civil societies can generally advocate for reforms in regulations and in articles that are already pre-existent, and even they can advocate to create new codes and articles, as I mentioned earlier, that are very specific to these digital ID systems in general. I think that for civil societies, I mean, when we publish our report, I feel like we will be able to shed light on a lot of the weaknesses that, not necessarily weaknesses, but a lot of the points that maybe some other governments missed when they were implementing their own digital IDs. So civil societies can take that as an example and try to map and maybe help governments, or maybe kind of have a structure for governments so that they can be able to have digital ID systems that are best put in place, that are inclusive, that are protective of users' rights, so that they can have articles of the law that are maybe preventive, that serve preventive purposes, such as articles of laws where we can find some articles that might prevent or help in preventing people from illegally accessing some of the information, or some articles that will repress the illegal access of this information. We can also they can also work. Civil societies can also see that there is a need for these articles to be, as Nay I think mentioned earlier, for these articles to be specifically tailored in each country, with taking into consideration the condition of each country. So that would be very important to do as well, because each country will have different personal information laws, and that would be very important to take into consideration as well. And I think last, civil society should definitely push to the publication, to the early publication of these laws, so that we can have an existing regulatory framework before the implementation of digital ID systems, so that everything can be properly regulated, and that maybe we don't have the same implications as other GCC countries might have had when they didn't, when they rushed the implementation of their digital ID systems without having the proper legislation and articles that would protect them.
Thank you, Omar. Now I have a question for you about international standards and best practices, and I would like to ask you, how do you think civil society groups can use these to better advocate for protection of human rights in digital ID systems, and where do you see the opportunities for them to be able to use these standards?
I think that civil society groups will find that in these international best practices, the ones that they can adopt to enhance their IT systems, all of them, or most of them at least, have human rights at their core, at the core of their provisions. So one example would be using, the EU GDPR or Convention 108 Plus as amended recently, where providing for individual and data subjects' rights to enforce their right to privacy. This is their human right to privacy. So they do have human rights at the core of their provisions in some sense. And what I think is that civil society groups should use these best practices as references when advocating for what they call, or what we call, good ID. And rather than simply denouncing wrongdoings of certain countries, I think the message that CSOs would wish to convey on the ID agenda can be much more powerful if it is solution-oriented, and if it suggests international best standards and best practices for countries to align with.
Thank you very much. The next question is for Subhashish. And Subhashish, could you maybe talk a bit about some of the key tactics and strategies that civil society groups in India resorted to either during or before or after the systems roll out in India? And what can civil society groups in the Arab region learn from those tactics and strategies?
Sure. I think one thing that the civil society did here remarkably well is they escalated, excuse me, they escalated objectively on many fronts the challenges and the exclusions that people with different kinds of say disadvantages and lack of access faced. So their approach to the entire issue was not necessarily to criticize the particular government that is in power, but to showcase what is excluding many marginalized groups. They showcased with data and not just anecdotes, so the anecdotes sort of are built around the evidences that they managed to create, and these evidences are around the fact that we need to battle the abuse by authorities that are using people's private data by creating public data. So we are creating public databases to showcase that the authorities are abusing people's private data, and that's very important. There's an openness component in that, and they also showcased how proprietary software, but also proprietary frameworks are dangerous to the health of a country. We claim to be world's largest democracy, but we have at some point forgotten the democratic practices that we should have in place. Without a data protection law, for instance, we launched a project that is so massive that is built literally around collecting private data. So that was a big realization that people have had because of the work that the civil society did. And I think that's very important. That is something that could be replicated, asking public authorities for accountability, to admit when they fail to use things that are supposed to be there as a human rights best practices, and so on. Privacy as a fundamental right did not exist in our constitution, and that was incorporated because of the challenges that people saw because of launch of a project like Aadar. So massive abuse of privacy was something that was not witnessed by the society to begin with, and the civil society documented, they shared that widely. I think that's very important. Making legal reforms based on the evidence, based on the challenges that are faced. In fact, many of the rights advocates or technologists from India contributed to Kenya's Huduma Namba. And I think because of the massive scale, because of the population of India, things became more visible to the world world outside India. And that was very useful, because when new countries are launching their biometric ID programs, there is at least some documented evidence that when something that doesn't work in a multilingual and diverse country like India, it might not also work in a country that is more homogeneous in many ways, because the challenges that society that has where many people have disabilities is same no matter how homogeneous a society is. So that's one common challenge for every single society. So I think these are the few things that I see as learning from the challenges that we've had here in India.
Thank you very much, Subhashish. I don't see any comments or questions. Please, moderators, if there are any questions, if you can just let me know. So we have 5 more minutes, and we don't have any last questions. So I just want to give each one of you 1 minute to share any final thoughts, comments that you have as we wrap up this panel. If there are no,
I was just I was wondering if Omar wanted to go first and in what turn. I think that, you know, the digital ID agenda is quite complicated and quite complex, as we've seen. And what I do believe is that it's going to take a lot of hands to make sure that these digital ID systems are implemented in the right way, and to get where the Sustainable Development Goals of the UN want us to get. And in that sense, I think that it's a multi-stakeholder approach that CSOs, together with international development organizations that are working on the topic, but also governmental entities, and maybe opening it up sometimes to the public, and public consultations, as was mentioned, are going to have to cooperate to make sure that all of these challenges are overcome.
Okay, thank you. And as we were wrapping up, there is a question for you, Subhashish. Do you think the public accountability should also be extended to private companies contracting with governments to roll out digital ID?
Well, I think it is probably it probably would be a good way to look at any biometric ID or any digital ID program as a whole, and not necessarily who is playing what role. Of course, a program that is massive in scale will have different stakeholders, key stakeholders that would be responsible. And each government would take a call based on their access to technology, their understanding of the international law, and so on and so forth. But I believe that the accountability should be applicable to the system, and not necessarily to who is playing what role. But by that definition, it also is applicable to a private company, because in that case, a private company is providing service to the government, to a public entity, and that public entity is responsible for ensuring safety of citizens. So I think they are responsible because of their contract. That the nature of the contract is very public facing, and not necessarily just a client and service provider arrangement. In this case, the client is the government, and the government is providing service to the people. So I would still stand there saying that yes, that accountability should be applicable to the private company that is responsible.
Thank you very much. Well, we just have 1 minute, 2 minutes, and I would like to thank you all. Thank you to the speakers for these very helpful presentations and for these informative perspectives and thoughts that you shared with us. And I want to also thank all of the attendees that have made it to this panel. And yeah, I hope you all enjoy the remaining days of Bread and Net, and thank you all.
Thank you so much.
Thanks, everyone.
Thanks so much
It's a pleasure
for
to
having
be
us.
here. Thanks, everyone, for listening to us.